Hi, everyone. This is Debbie Kristen. I'm an underwriter with PUA. I want to thank you for joining PUA Arch and Construction LLC for today's webinar. PUA and Arch is very committed to providing quality risk management services to its insureds and their brokers through Kent Holland and their team of attorneys. Our speaker today is Joanne Decker of Construction Risk LLC. Joanne, it's all yours.
Thank you. Thanks everyone for joining us today. We're going to be going over some federal law issues or federal employment law issues that can affect your offices, either as an employer or as an employee. I've got a bunch of slides to go over today, and it's very possible we won't get to all of them, but the information will be there for you should you need it. I'm going to start. So this is about employment law. We're going to be discussing learning objectives today and reviewing federal employment laws, discussing Title VII and other anti-discrimination laws, the Family Medical Leave Act, FLSA, the Fair Labor Standards Act, and COVID, which is always with us. Start with our federal anti-discrimination laws. These are enforced by the EEOC. States have other laws that may expand these laws or expand coverage, but what we're going to be looking at are Title VII, which covers race, color, national origin, religion, and gender. Pregnancy Discrimination Act, which obviously covers pregnant women and women who are postpartum. The Americans with Disabilities Act, which covers people over the age of 40. The Americans with Disabilities Act covers disabled Americans. Age discrimination in employment covers people over 40 in the workplace. We have the Equal Pay Act, which only applies to disparities in pay between men and women. You can still recover damages if you are discriminated against because of your other protected classes, your race, your national origin, etc. But equal pay only applies to disparities in pay between men and women. And then the Genetic Information Non-Discrimination Act, and that relates to people who you are genetically related to that your employer can't turn around and say, well, your family has a history of mental health disorders, therefore we're not going to hire you. It would cover something like that. And as I said, state and local laws may expand and add workplace protections, including age protections for people over the age of 18, military status, marital status, family status, personal appearance, political affiliation, and then anything that private employers may have on their own policies that may be included in here or maybe included under federal law. They can expand that. It means you can't discriminate against people because they're married or not married, they're fat or not fat, political affiliations, things like that. And the question becomes, what employers are covered by the federal laws? You have to have at least 20 employees to be covered by Title VII, the Age Discrimination Act, GINA, and the PDA. The ADA applies to employers with at least 15 employees, and the Equal Pay Act applies to almost all employers. So that's where states come into play for the state protections, where employers with less than 20 or 15, if it's the ADA, have their own state protections for employers and employees. For example, I have here the District of Columbia Human Rights Act applies to any employer that has only one employee. So it could be the owner and you. Other states have maybe 5 to 6 employees. If the employer is less than that, then there may be no coverage under some of these federal laws, or under the state laws, excuse me. So the question becomes, what is illegal under these laws, under the federal laws? And we have a category called disparate treatment. And this is treating an employee differently from employees outside the employee's protected class. So I have some examples here where Hispanic employees are not promoted because of their race or national origin, or a school hires only women to be kindergarten teachers, or an employer refuses to hire an applicant because the applicant has a speech impediment. So you're being treated differently because of your protected class, even though you are, you're qualified for the job, but for some reason you're not getting the promotion, then that would be disparate treatment. So you're being treated differently. Then we have disparate impact, which is a facially neutral employment policy that has a disproportionate negative effect on a protected class. So here my example is you have a delivery company, say like FedEx, says all employees must be able to lift 75 pounds. Well, the affected classes are going to be women, older workers, and disabled workers because they are more likely to be unable to meet that 75-pound lifting requirement. But clearly an employee who works in the accounting or IT or a corporate office of, say, FedEx, they don't need to be lifting 75 pounds. They're not out on the trucks. So that type of overall company policy would have a disparate impact on those groups of people. Another company requires all workers or all employees to work weekends. An affected class there may be religion. People who observe the Sabbath may not want to work or be able to work based on their beliefs. So in that case, it would be discriminatory to say everyone's got to work weekends to people of those affected classes. Now, if you're in a religious class, there is a religious accommodation similar to the ADA's reasonable accommodations, where you can ask for an accommodation based on your religion. We have a hostile work environment, and that's usually what we see with sexual harassment cases are examples of hostile work environment. And that is a hostile work environment is created by unwelcome conduct based on an employee's protected class. So if you are being harassed, given bad assignments, being retaliated against because of your protected class, then that's a hostile work environment. The federal standard is that the unwelcome conduct must be severe and pervasive. The Supreme Court has held that petty slights and annoyances and isolated incidents do not rise to the level of a hostile work environment. And it's a fairly high standard to meet. And so many times employees will lose a case because they can't meet that severe and pervasive standard. Now, some localities and or states are adopting what's called a reasonable person standard, which is a much lower standard that would an employee would have to meet. Montgomery County, Maryland is one of those states. So if somebody comes into work and makes an inappropriate comment, that is generally not going to be severe and pervasive. It may not even be a reasonable person standard. Basically, the Supreme Court said we all have to put up with some inappropriate comments or inappropriate conduct in the workplace. If it becomes severe and pervasive, then you may have a claim for the hostile work environment. And again, under the Montgomery County law, it's a reasonable person standard. What would everybody else think? What would anybody normal person think about that conduct? Remember that when we're looking at this kind of conduct, bad management by itself is not illegal. Being a jerk isn't illegal. No one has legislated against that yet. What you do have to remember is that bad conduct, if it's tied to one of your protected classes, then it is illegal. So that if the manager is only picking on women, or the manager is only picking on Hispanic people or people of a certain religion, and creating a hostile work environment, making comments about those people or other people in their protected classes, then that bad management does rise to the level or can rise to the level of hostile work environment. Sexual harassment, like I said, is the classic form of hostile work environment. Sexual innuendos, touching, other comments about women or body parts, things like that, that all falls under a hostile work environment. The fourth area that we look at in the EEOC laws is retaliation. And that is also illegal. People always, not always, but many times when we're looking into trying to find proof of the discrimination or proof of other illegal conduct, people will say, I don't want to say anything. I don't want to get involved because I'll get retaliated against. I'm going to get fired. If I speak up in favor of my coworker, I will get fired. That conduct is also illegal, whether or not you're the person reporting it or you're the person who is being subjected to any of the discrimination. So again, your protected persons are people who report illegal activity directed against themselves, employees who take part in an investigation or provide testimony in a court proceeding or even to the EEOC, or employees who report illegal activity directed at coworkers. So if you see that the manager is berating somebody because of their sex, calling them names or making comments about them, you can report that conduct. It doesn't have to be directed at you. You can report that as well. And then if you get retaliated against, you can report that as illegal conduct. And the retaliation can take several forms. It can be, the obvious one is you got fired. The other ones would be you got a demotion. Maybe you're no longer getting the good overtime assignments. You're not getting any good assignments. Your job is kind of made redundant, things like that. Things that everything was fine until you spoke up and said something about illegal activity, and now things have gone bad. So that would be illegal as well. And the claim for retaliation has 4 components. First, the employee's got to engage in protected EEO activity. The company must know about the protected activity. If you didn't do anything and all of a sudden the boss is picking on you for some reason, then that's not the reason that the boss is picking on you. The company also has to know about the protected activity. If you go to the HR office and you report your manager, and then your manager fires you, but the manager never knew that you went to the EEO office, then the manager cannot be retaliating against you. They're just being bad managers again. So the company or the person taking any adverse action has to know about your activity. So again, you have to suffer an adverse employment action, the termination, bad assignments, a pay cut, not getting your request for paid time off approved. And then there has to be a nexus between the EEO activity and the adverse employment action. If I worked for a manager 15 years ago and they did something and I reported the manager, and now it's 15 years later and I'm working for the same manager and something happens, and I start getting bad assignments, a court's going to have a hard time finding that there's a connection or a nexus between what happened 15 years ago and what happened today. And it depends on the court, and it depends on the circumstances, how far apart things can be. Sometimes courts will say it has to be a couple months. I've had a case where an employee, he was a federal employee, and he reported harassment, he filed a claim, and he lost on that claim, but then he had some health issues, and he got an investigation by the Inspector General of that agency. And about 9 months later, this report came out that said he had acted badly, so his manager demoted him. And so even though it was 9 months or almost a year later, the judge found that this was connected and supported a claim for retaliation. So those are our 4 areas. Again, there's disparate treatment. People are being treated differently because of their protected class. Disparate impact. What seems to be okay as a job description is not, because it affects people, certain classes differently than others. The hostile work environment, and then retaliation. Now, another component, so here we go. So what should employers do? We would suggest that employers have a policy that prohibits discrimination in the workplace, provide training, You're supposed to be posting posters in the employee break room. There's all sorts of posters. There's the EEOC poster. There's probably an OSHA poster, Fair Labor Standards Act, FMLA. There's a lot of things. Somewhere in your workplace there should be these posters so that people can look at this information and find it. And employers should have an effective policy for employees to report discrimination, and employers to investigate and take appropriate action when discrimination is reported to them. What should employees do? Well, you should be aware of the company policies. Be respectful of your coworkers and the differences we all have. If you're harassed or discriminated against, tell the person to stop their conduct. That's usually your first line of defense. If that doesn't work, or you're reporting, if it's your manager who's discriminating against you and your reporting process is to tell your manager, that's really not an effective process. So you should be able to go around that person to the HR folks. If you don't report harassment or discrimination in a timely manner, the company can avoid liability to you because you didn't give the company an opportunity to investigate and correct the alleged illegal actions. So you may be frightened. It's kind of scary sometimes to go forward either to your HR people or to the EEO office. They're supposed to do their job and help you out and move on from there. Okay. Mentioned earlier, we've got the Americans with Disabilities Act. In addition to not being allowed to discriminate against people because of their disabilities, the ADA requires employees and employers to engage in a interactive process to determine if this person needs a reasonable accommodation. So the reasonable accommodation is for a qualified individual with a disability who can perform their essential job functions with or without a reasonable accommodation, unless doing so would cause the employer to incur an undue hardship. So there's a lot going on in that sentence. An individual is qualified if they have a physical or mental impairment that substantially limits a major life activity. Again, while disabilities such as vision loss or being confined to a wheelchair are very obvious, other physical disabilities such as epilepsy or diabetes are covered by the ADA, and mental impairments such as PTSD, panic attacks, autism. These all affect the major life activity of thinking, and these are covered by the ADA as well. So that's a qualified individual has a physical or mental impairment that substantially limits a major life activity. So an employee with a disability, a qualified employee, is supposed to engage with the employer in the interactive process to determine what, if any, accommodation is going to allow this employee to perform his or her essential job functions. Employers are not supposed to look at an employee and go, oh my gosh, he's in a wheelchair. We better offer him a reasonable accommodation. Wait for the employee to come to the employer to ask for that. Maybe the employee doesn't need an accommodation. Maybe they've got everything they need. Examples of a reasonable accommodation, providing specialized computer screens, desks, chairs, and lighting for people who have mobility issues or vision issues. Those are helpful things, and they don't cost much. Allowing an employee to take intermittent leave to attend medical appointments for dialysis or chemotherapy, those are covered. They would also be covered if you're taking a family member to an appointment. That would be covered probably. That kind of crosses over with the Family Medical Leave Act as well. Providing an employee with a quiet private area if they realize they're about to suffer an epileptic seizure. That's another area that is really important. These are people who don't have the obvious physical impairment. You don't know that they're ill until they become ill. So providing these kinds of reasonable accommodations are going to help these people come to work every day. it's my personal interest here, is service animals are protected under the Americans with Disabilities Act. Importantly, only dogs and miniature horses are considered service animals. Miniature horses, they're probably about the size of a Great Dane. They can pull things, they can carry things. So that's why they're covered. Emotional support animals are not protected under the ADA. I think one of the big issues even before COVID was people getting on planes with a variety of animals. They were support animals. You know, people brought, there's a peacock somebody brought on the plane. They are not covered under the ADA, only dogs and miniature horses. Service dogs are trained to perform a specific task for their person. They are not there to be pets. They are seeing eye dogs. They carry and pick up items for their person who maybe has a physical disability. They can't pick up things or carry heavy things. They assist their person with mobility. Very interestingly, they can detect a change in blood chemistry of people who have epilepsy or diabetes or other similar disabilities, and they can alert their person that they're about to suffer an episode, so that the person can find a safe place to recover, which, you know, many times they just need to be on the floor, but they don't need to be on the floor in the middle of an office area. So they would need to have a private office that they can go to until their seizure passes. Service dogs can be any breed, any size, any age. These are working dogs. They're not pets. They do not need to have a jacket on that says, I'm a working dog, I'm a service dog. Owners do not join a registry that says this is a service dog registry. There's no such thing. There's some companies that will try to take your money and say, you know, I'm a registered service dog. Well, it's not under the ADA. People sometimes put a jacket or a vest on the dog so you can see that, you know, I'm a service animal. But they can be pit bulls. They can be chihuahuas. Usually when certain dogs are very good for things like seeing eye dogs are usually labs, golden retrievers. German shepherds are good as well. Dogs with a good nose that can detect a person's blood chemistry, they can be service dogs. I do know someone who's got a son who has severe peanut allergies, and they've got 2 beagles who can detect in his food whether there's peanuts or other nuts that would hurt him. So these dogs, again, are working dogs. They are not there to be a pet. They're not there to have people play fetch with them all day. Be ready, aware that there is no one size fits all for reasonable accommodations. The interactive process is designed for the employer and the employee to figure out what works for me, what works for us. If the employer can show that there's an undue hardship on providing an accommodation for the employee, then the employer may not have to find that accommodation. It can be too expensive or disruptive. And the employer can offer alternatives. And if there's more than one accommodation that works, then the employer has the option of choosing which one to provide. It's not necessarily up to the individual, but you know, I say give the individual a break and give them what they want. I thought I had a slide in here about the Pregnancy Discrimination Act. Maybe it's later on, but that also is an important reminder that, oh, I'm sorry, that's under the FLSA. That's what I'm going to come on. We'll talk about that. It's not the PDA, it's the FLSA. I'll come back to that. If you want more information on illegal discrimination in the workplace, you can go to the EEOC's website, eeoc.gov. And for companies that have less than 20 employees, you can go to your state's official webpage. There should be something in there. Any questions, any comments or concerns at the moment?
I would just take a moment and ask them to put chat in questions.
If anyone's got a chat question they'd like to put in there, we'll go on. Some other things, any messages? I get a drink of water. Okay, no comments. Okay. The USERRA, the Uniform Services Employment and Reemployment Rights Act, USERRA, is not covered by the EEOC. It's covered by the Department of Labor. I just included here at the end of the discrimination discussion. USERRA protects civilian job rights and benefits for veterans and members of the active and reserve components of the U.S. Armed Forces if they need to leave their jobs because they get called up. Returning service members must be promptly reemployed in the same position they would have been in had they stayed and not been absent for military service. They get the same seniority, same status, same pay, same rights, same benefits. That would be determined by their seniority. USERRA prohibits discrimination, harassment, or other retaliatory actions directed against returning service members, and employers may not retaliate against them because they were on military leave. The employee should give the employer as much advance notice as they can that they will be leaving. That may or may not be possible for a lot of reasons, national security being one of them. So this person may leave on a short, very, very short notice. And they may leave the company just dropping something in the company's lap. And when they come back, some people may have hard feelings. Hey, you left us in the lurch. Well, you can't discriminate against the USERRA people. They're protecting their company. They're doing a service for us. So their jobs are protected. And this slide is who's eligible. You have to be absent from the civilian job because of your service in the uniformed services. So you can't say, well, I'm going to a veterans reunion. That's not going to be covered. You actually have to be called up and get back into service. So again, the person should give as much advance notice that you can. And again, if it's precluded by military necessity or perhaps national security, then they may just really leave on very short notice. The total time of military service that the employer can use while they're employed by this company is 5 years. So if they're gone for 2 years and they come back and they get called out again for 2 years, and they come back and they get called out again, they've only got 1 year left. The employee must not have been dishonorably discharged. And the person's got to come back to their civilian job in a timely manner or submitted a timely application for reemployment, unless it's impossible or unreasonable. So if I'm discharged and I'm ready to go back to work, I can't come back a year from now and say, gee, I'd like my job back, unless maybe I had another reason, which maybe perhaps I was injured while I was in the military. Or something else happened that explains why and is reasonable why I couldn't come back to work sooner. So that's USERRA. That's for our service people. And they do a good job for us. So let's help for them. Again, USERRA provides protections for our disabled vets. Your health insurance can be continued if you're gone. So if you've got employer-based health insurance, or you have dependents, they can be covered for up to 24 months. And then when they return, they can get reinstated to the health plan, and any waiting periods or exclusions for pre-existing conditions are going to be waived, except for service-connected illnesses or injuries. Okay. Now we're going to move on to the Family and Medical Leave Act. The FMLA entitles employees of covered employers to take unpaid job-protected leave for specified family and medical reasons with continuation of their group health insurance coverage under the same terms and conditions as if the employee had not taken leave. So who are eligible employees? You've had to work for a year, and you get up to 12 weeks of leave in a 12-month period. So you can take it intermittently if that comes up later. So you can take leave for the birth of a child or to care for a newborn child within 1 year of the birth. You can take leave the adoption of a child or foster care placement. And that goes for men and women. It's also, you can take leave to care for your spouse, child, or a parent who has a serious health condition. If you have your own serious health condition that makes you unable to perform your essential job functions, you can take time off. And any qualifying exigency arising out of the fact that the employee's spouse, son, daughter, or parent is a covered military member on covered active duty is also entitled to FMLA leave. And those people can get up to 26 work weeks of leave during a single 12-month period to care for a covered service member. And the uncovered employees must be a private sector employer, a public agency, a federal government person or company, public or private elementary schools, a private sector employer, and I'm assuming that's everyone who's listening here is private sector employer or employee. The employer must have 50 or more employees and 20 or more work weeks in the current or preceding calendar year. It includes a joint employer or successor in interest to a covered employee, right, from a covered employer. So if you've got less than 50 employees, the FMLA is not going to cover you. You have to start looking at your state requirements. The requirement for 20 or more 20 more work weeks, it's usually seen in seasonal employment. People work Christmas holidays, maybe the summer employment. People who have their summer jobs or working at the beach or something like that. A design firm that has less than 50 employees could qualify if it hires additional temporary employees for a big project, and that runs for over 20 weeks. And then you have joint employer. That's usually staffing companies that might provide people for your staff. Or a successor in interest would be you work for a company that gets merged or taken over. So that's how you can get your 50 employees and the 20 or more work weeks. Who's the eligible employee? You're working for the employer. You've worked for the employer for at least 12 months. You have at least 1,250 hours of service with that employer during the 12-month period immediately preceding the leave. And you work at a location where the employer has at least 50 employees within 75 miles. That might start proving interesting with COVID as more and more firms are having people work remotely. Obviously, before COVID, you worked probably within 75 miles of where you worked. Now, with COVID and everyone thinking, hey, I don't actually have to show up, that might change. I don't know. The 12 months of employment don't have to be consecutive. So that means any time previously worked for the same employer could be used to meet that 12-month requirement. So within that 12 months, if you worked, let's say you've got a summer job and then maybe you work for the same employer Christmas for some reason and the holidays, you might get your 12 months of employment in using those hours. Some additional FMLA information. FMLA leave is unpaid. Under federal law, it is unpaid. Eligible employees, you can use accrued paid time off, whether it's sick leave or vacation time. Employers can require employees to use up their paid vacation time before using up paid sick leave if they want. Your job is protected for up to 12 weeks, so that when you come back after your FMLA leave, your job is still there for you. If you cannot return after 12 weeks, you may lose your job. So be aware of that. Some employees will extend it, will help you out. They may offer you a short-term disability. There's also long-term disability available. Intermittent leave or reduced schedule leave, going to physical therapy or taking a family member to regular medical appointments or chemotherapy. That would be covered under FMLA. So if you've been in an accident and you have to go to FMLA, you've had surgery and you go to physical therapy twice a week, that time could be covered under FMLA. When employees are out on FMLA leave, they should not be working. That means no business calls, no emails, no remote working. It's very easy to say, oh, I'm just going to check in with somebody at work. I'm feeling pretty good today. You're not supposed to do that. And employers, you're not supposed to allow it. Your healthcare benefits will continue while you're out on FMLA, provided you continue to pay your share of any health insurance premium. So if you're paying half the premium, you have to make sure you're still paying that. As I said, states can expand that coverage. The District of Columbia, FMLA applies to employers with at least 20 employees and provides for 16 weeks of unpaid medical leave and up to 16 weeks of family leave during a 24-month period. And that eligible employees must only work 1,000 hours within the previous 12 months. Connecticut just recently changed their law. It applies to employers with 1 employee. Eligible employees must be working for only 3 months, no minimum hours, and allows for up to 16 weeks of unpaid leave in a 24-month period. Or if you're working for the state of Connecticut, you get an extra couple of weeks. An additional 2 weeks may be available for pregnancy-related conditions, and Connecticut's FMLA also provides leave for military caregivers and victims of domestic violence. In Washington state, workers are eligible for up to 12 weeks of paid leave a year, and some employees are eligible for up to 16 weeks. Eligible employees who can take paid leave, receive as much as 90% of their weekly wage with a $1,000 a week cap. And employees must have worked at least 820 hours over the previous year. And full-time, part-time, temporary, and seasonal workers are covered. So again, states can expand the coverage. What should employers do? Check your state laws. If you're, even if you're covered under the federal law because you have more than 50 employees, you're still going to be subject to your state laws. So check those out. Provide employees with information about how to apply for FMLA leave, the process for reviewing and approving these requests. Be prepared to fill in for employees who are going out on FMLA leave, especially if it's for an extended period of time. You can consider hiring a temporary employee or reassigning job duties. Obviously, someone who gets into an accident or has emergency surgery, they can't give you any notice. They're just in the hospital, so usually a family member will be in contact with the company. On the other hand, if you've got surgery that you know is coming up, if you're pregnant, you have a pretty good idea when that baby's coming. So you need to let your employer know. And employers, remember the employee is on leave. Like I said, don't call them up and ask them, hey, where's something? You can call them up and ask them in general how they're doing, but you shouldn't be asking them about job-related matters. Employees, know your rights when you're asking for FMLA leave. You may have to provide medical or other information to support your request. A doctor's note saying John has to be out for the next 3 weeks isn't going to be enough. The employer's got a right to know, have some information about your leave and why you need to take it. And again, provide your employer with much notice as you reasonably can. And again, remember, you are on leave. Do not check your emails, do not call work. Don't worry about completing projects. You're on leave. People will be able to take care of it. Another quick break if anybody has any questions. We're going to move on to the Fair Labor Standards Act. Any questions on anything so far? Okay, so we'll move on to the Fair Labor Standards Act. FLSA covers all employees, pretty much. Covers minimum wage, overtime, record keeping. It also has youth employment standards. Generally, while young people may work, the Fair Labor Standards Act, I think, prevents them from doing things like driving forklift trucks, operating heavy equipment. You don't want anybody's high school senior driving around with forklift. The Fair Labor Standards applies only to employers whose annual sales total $500,000 or more, or who are engaged in interstate commerce. If you make $500,000 or more, you know that. What is interstate commerce? It's very broadly defined. Using the mail to send or receive interstate mail subjects you as an employer to the FLSA. Using company phones to make or accept interstate calls or use computers to place or accept orders can subject an employer to the FLSA. If you are a very small business and you just put up a sign and say, come get a cup of coffee and that's it, you may not be subjected to the Fair Labor Standards Act. But almost all employers are going to be subjected to this. Even if you don't make the $500,000 mark, you're going to be in interstate commerce. If you've opened up your computer today, you're engaging in interstate commerce. Get a mail, get a letter, you're interstate commerce. The FLSA minimum wage requirement, the federal minimum wage currently is $7.25 an hour. Many states have enacted their own minimum wage requirements. California here is $14. District of Columbia is $15. Georgia and Wyoming is $5.15, unless the employer is subjected to the FLSA. So if you're in Georgia or Wyoming and go to a Starbucks there, your coffee may cost a lot less than if you go to the District of Columbia. Workers who work for federal contractors have a minimum $15 an hour wage. And then 18 states follow the established federal minimum wage. So like Georgia and Wyoming, assuming they can find a company that is not using the mail or computers, they can pay $5.15 an hour, but otherwise they will follow the $7.25 hourly rate. And states are going to expand those. The FLSA also covers overtime. Covered, not exempt employees must receive overtime pay at the rate of time and a half for all time worked in excess of 40 hours in a work week. Okay, so a work week is a fixed and regularly occurring period of 168 hours or 7 consecutive 24-hour periods. It can be whatever the employer decides, Monday to Sunday, Wednesday to Tuesday, Thursday at noon to the following Wednesday at 12 or 11:59. That can be your work week, but that's what you're looking for, how many hours in that set period of time. Even if you pay every 2 weeks or you pay once a month, you still have to look at that 7-day period. Employers can establish different work weeks for different groups of employees. I have a factory worker versus the administrative staff. They may have different work weeks. They can do that. But if you're in a group of employees, your work week is the same as everyone else in your group. Employers do not have to pay overtime rates for holiday or weekend work unless they go over the 40 hours in the work week. There is no limit on the number of hours employees over the age of 16 may work in a work week. So you can work people 100 hours a week. You got to pay them a lot of overtime for that, but there's no limit. Now, there's the last point here is if employees who suffer, i.e. allow non-exempt employee to work in excess of 40 hours in a work week must pay overtime. So if I work from 9 to 5, and I leave at 5, and I'm meeting my friend for dinner, and I say, oh, well, I'm not going to meet my friend until 7. I'm just going to put in, some extra time here because I want to catch up on some work. Now, because I work those extra 2 hours, I go over 40 hours in a work week, I'm entitled to 2 hours of overtime. So the employer must pay that overtime. And if you do that continually, the employer is going to take steps to make sure that you do not work those overtime hours, sneak them in, essentially. Everybody's going to maybe get a few hours overtime in now and then. But employers have the right to determine their employees' work hours, and they don't want to be paying time and a half if they don't have to. States also have some different overtime requirements. Some states, like California, say that you must pay time and a half for any hours worked over 8 hours in a day, 40 in a week. And if you work on 7 days in the work week, you get paid overtime for the first 8 hours of that 7th day. Double time is required for any hours worked over 12 hours in a day or in excess of 8 hours on any 7th day of a work week. So if you're in California, make sure you know what your overtime requirements are. Colorado also has some different requirements. In addition to paying for the regular 40 hours, anything over 40 hours, if you work, employees work over 12 hours in a given day, or for over 12 hours, consecutive hours in a day. So if I start working at 6 o'clock at night and I work till 6 a.m. in the morning, or I work till 7 o'clock in the morning, I've worked over 2 days, but it's consecutive hours. Alaska also has an overtime requirement if you work more than 10 hours in a work day. Employers have to decide who are exempt employees and who are not exempt. I see I'm getting close to running out of time already. So you have to look at who your employees are, how much they're paid, how they're paid, and what kind of work they do. We've got exemptions for employees. For an exempt employee, they have to make $455 per week. They paid on a salary, and they have to perform exempt job duties. The types of exempt employees are executive, administrative, professional. There's computer employee, outside sales, and highly compensated employees. So you have executive employees. They're paid not less than $684 a week. They manage the business, and they should be managing at least 2 other full-time people. They also usually have the authority to hire and fire. Professional exemptions, you have your learned professional. Salaries, primary duties are advanced intellectual knowledge, which requires a consistent exercise of discretion and judgment. And usually you have to get this learning through specialized education or instruction. And it's a prolonged course, you know, like a college course, not a 1-hour CLE. We have creative professionals. Again, they're performing creative, inventive work. Administrative exemptions are going to be your IT, accounting, HR people. They're doing office work, non-manual work. And then highly compensated employees have an annual compensation of at least $107,432 a year and regularly perform at least one duty of an exempt professional or administrative employee. It did not include our computer employees. Those are your computer tech people. Outside sales, I don't think that would apply to anyone here in the group. If you don't properly classify, those are your exempt employees. Now, this touch here on independent contractors. If you don't properly classify your employees and your independent contractors, an employer can become liable for taxes paid that should have been paid for the independent contractors. Probably in every contract that we review, there's always something in there that says, you are an independent contractor, you are responsible for your employees' payroll, taxes, you are responsible for this. That's the independent contractor. They don't want to be, you're controlling the work. So the proper classification of the independent contractors, they have behavioral control, financial control, relationship control. So if you're everything in name and work that you do, you're just like the guy sitting next to you doing the same work, everything about you is the same, and one of you is an employee and one of you is an independent contractor, chances are you're both employees or you're both independent contractors. There's tax considerations if you misclassify your employees, or as the independent contractor, if you are misclassified. There's tax consequences to that. So make sure you're getting proper classification of employees. Few final FLSA considerations. Independent contractors are not covered by the FLSA. You're not entitled to overtime and benefits. Independent contractors are not covered by the federal employment laws, the discrimination laws. So if you go to work as an independent contractor and somebody's harassing you and not paying you the same as somebody else, you're an independent contractor. You're not covered by the federal laws. Private employers may not pay your hourly employees in comp time to avoid paying overtime. Employers can only dock the salaried employees' pay under specific circumstances, and that usually involves very serious disciplinary action. The FLSA requires employers to give non-exempt nursing mothers reasonable break time to express breast milk for up to 1 year after the child's birth. The employers must also provide mothers with a private place, not a bathroom, that is shielded from view and free from intrusion by coworkers and the public so they can express breast milk. Exempt mothers do not have the same protection under the FLSA, although state laws may provide additional protections. And just this quote from the DOL website, Department of Labor, the department encourages employers to provide breaks to all nursing mothers regardless of their status under the FLSA. So what should employers do? Make sure you're properly classifying your employees. Require your non-exempt employees, your hourly people, to accurately record their hours. If you don't want them working, send them home. And know the difference between employees and independent contractors. Employees should also know and understand their status in the company, follow the timekeeping rules, for exempt employees, you don't have to work 40 hours a week. You can work 35 hours a week. You can work 20 hours a week and still get the same pay. You can't have your pay docked for that, but you may lose your job if you're routinely working less than 40 hours a week. COVID, hopefully it's gone. Obviously, it's changed how things have worked. More and more people are working remotely. It's got a new workplace. Some quick COVID thoughts. Employers may require that all employees who enter the physical workspace are vaccinated. Employers can ask all employees who come to the workplace to have been, if they've been vaccinated, that should be vaccinated, not diagnosed with or tested for COVID. You can't ask someone who is physically coming into the workplace if they have family members who have COVID. That would violate GINA, but you can ask if they've come into contact with anyone who's been diagnosed with COVID. You can ask people to wear a mask. There are some exemptions that are recognized, either religious exemptions or physical or health accommodations. People who ask for religious exemptions for not getting vaccinated, they must have a sincerely held religious belief, practice, or observance, unless it's going to cause an undue hardship on the company. And then health-related accommodations, many pregnant women and individuals with autoimmune diseases may be advised by their healthcare providers not to be vaccinated. So they may ask for an exemption to vaccination. If no reasonable accommodation is available, the employee can prevent the employee from coming into the workplace. Requiring unvaccinated employees to wear a mask or to provide evidence of a negative COVID test are reasonable. Employees who have been previously denied telework as an ADA reasonable accommodation may now be eligible for telework. Employers can encourage employees to get vaccinated with, some incentives, additional paid time off, a bonus of some kind. They have ample supply of hand sanitizers and masks available, and they should stay current with CDC guidelines. So that brings me right up onto 2 o'clock. I hope you've enjoyed this, learned something. Anybody have any questions? I can provide you with some more information. You can contact me. Here's my contact information. When you need continuing ed, you should send us whatever you need. Now I'm getting back. Anything else?
Well, for wrapping up, thank you everyone for participating, and make sure you get your CEUs. You'll get your a certificate from Ken Holland's group and Joanne. So please be sure to submit the proper information. Thank you again and have a wonderful weekend. Thanks,
All right.
Joanne.
I just got a quick note here about please share the PowerPoint. I'm assuming everybody saw the PowerPoint.
Yeah, we can see.
We do share it also online, so we will
Right,
be
okay,
sharing it in a few days.
Right, that'll be shared on. Participated. Thanks.